Thank you. Good afternoon and welcome to the Class Legal Webinar with me, Michael George, and my colleague, Aimee Fox. Aimee and I are members of the 3PB family group. We're a group of about 65 specialist barristers. I'm talking about standing outside the booth with a G&T, playing to hopefully my strength as a financial remedy specialist, but also trusts. And for those of you who are legal geeks, you can try and work out the cryptic references in that title. Aimee has a more useful co-specialisation in education. Aimee's going to be dealing with additional needs and the impact on family law proceedings. Education law is an important niche area. It's one I know very little about, and it's one that I'm very grateful to have Aimee on tap to call up when I need her for times like when it crops up in a case. And the good news is that, of course, if you brief Aimee, you'll get the gold-plated 5-star service, whereas I usually get the short phone call going, look it up yourself. Anyway, without further ado, I will pass over to Aimee, who's going to deal with additional needs and the impact on family law proceedings.
Thanks, Michael. And I should say, Michael is in our team, our absolute financial remedy guru. He's our go-to person. If you ask us a complicated question, it's usually gone via Michael. So he's much too humble. I'm going to start today running through the impact that additional needs might have on your case. Some of you, like me, might practice in private law, as well as financial remedy. So I hope that some of these topics might actually straddle both areas of practice. And I'm going to start today. Next, please, Michael. I'm going to start actually with 2 Children Act cases. For those practicing in the Midlands, you may already be familiar with these recent cases. They're both decisions of Mrs. Justice Leven. But it occurred to me that it's not only a child's additional needs that might impinge on the outcome of your proceedings, but also perhaps the additional needs of your client. So the first case that I looked at was West Northamptonshire Council and the mother, and it was about psychological assessments. So there was an application for a cognitive assessment. Mother's team then had second thoughts about that application and tried to withdraw it, but too late, said Mrs. Justice Leven. The can of worms has been opened, this application will be heard. There was no reference in the SWET to cognitive impairment, and there was no special educational needs statement, as it would have been called at the time that mother was at school. We, of course, call those education, health and care plans now, and we have done for a number of years. Mother's case was she was vulnerable due to age, past experience, mental health, and difficulty retaining information. Next slide. What was said in this case was that if you're making an application for a cognitive assessment of your client, it must be accompanied by proper evidence. And that must be evidence which shows the court that this case goes beyond the standard difficulties which many people may face. And in this case, it was in care proceedings. The court often in this case and in this judgment goes back to looking at, well, why can't parents' needs be met by use of language, explaining things? It's got to be absolutely necessary, Mrs. Justice Leven says, rather than something that's just nice. And it's only appropriate to have a psychological assessment if the advocate's gateway is insufficient. Next one. So one thing that was said in this case was that it would often be the case that if one parent has cognitive issues, that will have been identified when they were at school, during previous interactions with the LA, or in pre-proceedings work. For any of you who practice in education law, you may not have as much confidence that the court had in respect of cognitive issues having been picked up. I think we are probably much better in this day and age at picking up cognitive issues in school than perhaps would have been the case 20 years ago. So sometimes it depends on the age of your client, and it might still be worth looking around to see if there's any evidence of it, but still the absence of evidence from school doesn't mean it's not there. One thing the court said, slightly critical of guardian's position, was that if a guardian and the child solicitor thinks an application should be refused, then please do say so, don't sit on the fence. Again, just a reminder to use simple language, avoid jargon, and check that the litigant understands what's being said. Next slide, Michael. The final Children Act case that I want to talk about was about intermediaries, and it's West Northamptonshire and KA. In this case, the mother was profoundly deaf and had the assistance of a British Sign Language interpreter. Her cognitive functioning was in the low average range, and it was recommended that information be translated by an interpreter, but she also have an intermediary, again, recommending avoiding jargons. The intermediary didn't attend the final hearing. Next slide. And what the court did was go through a series of authorities from the Crown Court and come up with a number of points that are worth bearing in mind if you are having to apply for an intermediary for a client. Exceptionally rare for one to be appointed for a whole trial. It's not just a just-in-case basis. Facts and circumstances need to be considered. There have to be compelling reasons, not just because it would be better or improved. There are other adaptations, and just because you've got an expert recommending it doesn't mean it's determinative. Court can consider breaks and short questions, and making things easier. And the bad news is all parties agreeing is not the test. You've still got to convince the court. Next slide, please. I started practicing in education law about 12 years ago. It really opened my eyes to some of the difficulties that children and young people face when they're growing up, and caused me to think differently about how I approached family cases when the children had additional needs, particularly in terms of child arrangements orders as very blunt instruments, but also the financial package that you might want for your client or for the separating family to be able to move on. I have listed the Children and Families Act as your main piece of legislation. We've got a set of regulations, we've got a code of practice, and you might also find yourself looking at the Care Act and the Chronically Sick and Disabled Persons Act. Next slide. I have inserted the legal definition of special educational needs. It comes from Section 20 of the 2014 Act. And it's where a child has a significantly greater difficulty than the majority of others of the same age, or has a disability, and the definition is expanded. But watch out. Just because a child's first language is not English, doesn't mean the child has a special educational need. So English as a second language is not a special educational need, although I am aware that many schools will put in place some extra assistance for children to bring their language skills up. Next slide. So what we used to call a statement of special educational needs years ago, we now call an education, health and care plan. And why is that important to your case? Well, this document, and some of them that I deal with, will run to 30, 40 pages. That's before you get appendices. And what the document does is it will give you a description of the child's needs, very detailed. It will contain a list of provision in section F. Those are the things that the local authority has got to provide by law. And if they aren't complying with section F, they are acting unlawfully. It is legally binding in respect of section F and the local authority. And then you'll come to section I, where you will see the name of a school or a type of school. You will also have a section where parents are expressing their views. And if health and social care is relevant, you will also find recommendations in there. At the moment, the tribunal can only make recommendations in respect of health and social care needs. It can't issue binding decisions. But if your local authority is not following those recommendations, they will want to know about it, and they will want to know why, and that's potentially opening up a judicial review. It is, in my humble opinion, of huge evidential value. Aside from the whole description of the child's needs and what the child will be provided with, it contains usually appendices, and these appendices should be updated regularly. So you will get, you hope, a complete profile of the child. You will often find expert reports from educational psychologists, psychiatrists, speech and language, OT, physio, all very, very common, because in education law, we are a very specialist jurisdiction. We don't have the concept of single joint expert. Everyone brings their own expert. So it is perfectly normal to have 2 psychiatrists, 1 on each side, 2 ed psychs on each side, 2 physios on each side. Everyone has their own expert. It's a real expert-led jurisdiction, unlike in family, where we really struggle sometimes just to get an SJE. You might have a mixture of local authority commissioned reports, NHS, privately commissioned reports. And importantly, the EHC plan has got to be reviewed annually. So if you are in the middle of proceedings or embarking on proceedings, you should be fairly confident that you have got some up-to-date information about a child. You may find that your client presents to you a plan that hasn't been reviewed for some years. If that's the case, I'd be asking, why has the plan not been reviewed? And you can imagine in Children Act cases, in Schedule 1 cases, and also in some aspects of financial remedy, your ready-made package of evidence is absolutely crucial. Next slide. You will find in there probably information about social, emotional, mental health challenges. Does the child have difficulty coping with change, sensory issues, physical environment? We can see how some of this evidence is going to feed into the financial outcome. Does the FMH have to be retained? Is this going to be a case where there's shared care? What if there are really competing housing needs and money's tight? We'll look at relationship dynamics. And you might also find that there's some information about needs in school compared to home. It is not unusual to find behaviour very different at home to behaviour experienced by school. And often the court will rely quite heavily on what the teaching profession says, but your client may well have a legitimate argument if they say, my child is neurodivergent, my child manages all day at school, but when they come home, they simply bubble over and it gets really difficult. So do keep an eye on that, particularly if you're in private law proceedings and there's criticism of your client's parenting. It may not be your client's parenting. If the child is coming home and having a meltdown at the end of the day, it might be that they're overstimulated. Next slide. You'll also find other sources of evidence from schools: individual education profile, behaviour profile. Again, that can be quite important in terms of Children Act proceedings, attainment records, attendance records. And of course, if the school is not forthcoming, you have got your options of trying to get your evidence other ways. Next slide. If you are involved in proceedings where parents are in disagreement with the local authority, there is a tribunal that can decide. It can force a local authority to assess a child. It can force a local authority to issue an EHCP. It can decide the content of an EHCP, and it can decide which school the child attends. And it can also force a local authority to continue a plan, because these plans will cease when the young person turns 25. So one thing that you've got to think about, particularly in your financial remedy proceedings, is what my client is receiving now may not be what they are receiving in 5 years' time, when you get the ceasing of the EHC plan and all the provision in there. And also you've already gone over to adult services. Importantly, if you have a dispute about a school with a child who has an EHC plan, or any of these issues listed here, and parents don't agree because they're separated and they've got a different opinion, it's important to know that parents can go to tribunal and they can be separately represented, so they don't have to be on the same page. They can both present their cases and the tribunal can decide. Next slide. A few things that I've come across. I'm often instructed in cases where children have additional needs because of the crossover in my practice. If you are left in a situation where you are looking at a measure order or a sale that isn't going to be happening right away, you really want to have a think about bespoke triggers for sale. You could have trigger events such as the child attending residential school or the child attending school outside of area. You will want to think about the optimum time to sell. There might have been adaptations done to a home, which means there's a payback clause, so you need to factor that in. Residential schools can run for 38 weeks, or you might have a child who is there for 52 weeks of the year. So you might have a client who says, I'm not sure we need to retain the family home. I think we can move to a sale now because the child's in residential school. You will want to think about the importance of school. If your case involves a child who is at a highly specialist school, and that might be a state-maintained highly specialist school, or it might be an independent fee-paying school, bear in mind that some of the highly specialist schools for a residential placement can be well over 100,000 a year. Day placements can be 60, 70,000 pounds a year. And what people are often worried about is moving out of the local authority area. So one parent might say, I don't want to move out of area because child attends this school and it's in their plan. If a child moves out of county, then the new local authority takes over the plan. What you have to be aware of is they may not necessarily continue with the same plan. They may look at it afresh and say, we don't think this school is needed. We think the child can go to a different school, so that you do carry that risk. And there might be some merit in bringing in education lawyers to advise on how likely you think that risk is. You might want to think about any pending tribunal proceedings. If the parties are already in dispute with the local authority and a decision is waited, if you're waiting for a decision, then you might want that decision before you start arguing about housing needs, before you start arguing about income, earning capacity. So you're going to want to know what's child's education going to look like and where is it going to be. When the school is named in section I of the plan, the local authority pays school fees. And you can have prep in section I, mainstream independent sector prep. You could have independent sector secondary school named in section I, because there might be arguments that actually the child needs a much smaller class, fewer peers in the class. So don't be surprised to see schools which you may not ordinarily think fall into the category of being special schools effectively. You might also see in section I that the local authority has agreed to pay prep fees, but that's on the basis that your client transports to and from school. Transport's a really important issue for separated parents, and it is worth looking and asking them to look at the local authority's transport policy. Some transport arrangements to take a child from home to school twice a day, 5 days a week, can cost 30 or 40,000 pounds a year. And that's only, say, a distance of 7 or 8 miles. These aren't long journeys. So sometimes local authorities will be willing to reach an agreement that they'll pay fees, but you've got to get your child to and from school, because otherwise they don't think that the school is an efficient use of their resources. EHC plans are not means tested. So in terms of the education part, in terms of section F and section I, so if you're representing high net worth clients, it might be important that they understand their options as well. Think about the cutoff for any child-related benefits, CMS, etc. It may not tie in with this young person achieving independence. That could be a relevant factor. Consider Schedule 1 if you need to, if the child has a disability, and the extension beyond the 18th birthday. Think also about taking a longer view. If your client can't work, then there's going to be some other knock-on effects, including pension contributions. So you might want to factor that in. Next slide. You might want to think, if you don't have an EHC plan, if you're not meeting that threshold, but the child still has additional needs, who's going to pay? Therapies, weekly therapies can be expensive. Having professionals in the home can be expensive. Do you need to find a way to cater for that in your financial settlement? I've repeated the point there about, do you think that you need to go to tribunal to resolve some of these issues? What transport will be required? What's the cost? Can you get that funded by the local authority? Next slide. What about care and support in the family home? Will the needs be the same in both households? Is it going to be possible for a child to move between 2 homes? And is any statutory funding available? You will find that your clients face the difference between children's health and social care compared to adults' health and social care and the funding streams, and some of the means tested rules in terms of certainly, particularly social care. Next slide. What about statutory funding entitlements? I've said already that these EHC plans are reviewed annually, or should be. So think about whether or not your client might if it's on the cards that they might lose some of their support, likewise, it might be increased, but there is a risk of reduction in support. If adaptations are required to the family home, if someone has produced property particulars that might not at first blush seem suitable, is there a disabled facilities grant available? What could be done to improve the living arrangements? You want to think about key ages of when things could be made and when your clients might be making legal challenges. You know, for SEND, EHCPs 4, 11, 16, 18, 19, 21, transition into adulthood. And there's an uncertainty when you transition to adult services that people often find is a bit of a cliff edge. Statutory phase transfer deadlines, 31st of March, the local authority should issue those decisions. Anyone who's doing any private law work where even if the child doesn't have special educational needs, if you have got a dispute about secondary transfer and which secondary school the child will go to, think about getting your application in nice and early, because those applications have got to be made months before. It's one application per child, so your clients cannot be making separate applications. One child, one application, your hierarchy of your top 3 choices of schools. But to get a timely decision, those applications are really front loaded and you end up having to go to court, I think, a good bit earlier than you would ordinarily think of. Think about whether or not family finances can cover privately funded support or legal fees if there are challenges. Next slide. What about relocation? What if one person is suggesting cheaper properties out of county? I'm sure your client will do their homework in respect of what schools will be on offer. There is a real shortage nationwide of specialist schools. The EHCP would be maintained by the home local authority if they move out of county. It's the new local authority, and we've said already you're not guaranteed to keep that provision. Difficulties can arise where there's a 50-50 shared care arrangement, and local authorities will think about things like ordinary residence. You may be involved in a case involving a settlement where there's been compensation for negligence. You might have been through the Court of Protection. Don't assume that parties can use the settlement funds to fund costs associated with challenging decisions. So they may need a pot of money to fund litigation to make sure that the child gets what he or she needs. What about support in adulthood? In some of the cases that you are dealing with, the young person might never be truly independent. And you might have one party saying, I'd really like the young person to live with me. And I think that's probably on the cards. The other side might say, well, actually, there's the prospect of residential or supported living placements. You might want to check out the local area to see what's actually available and to see if it's suitable. Next slide. One thing that I have come across numerous times now is one party's ability to work being desperately affected by school calling and asking for the child to be picked up consistently, or a child not doing a full school week, that they're on a reduced timetable, or that they're persistent school refusing. If a school is frequently ringing parents to come and collect early, we would say that's probably at first glance indicative of a school that isn't meeting a child's needs, and actually is the key to deal with the education situation and get school resolved, and then your client will be able to work. Because people will say, there's nothing I can do, this situation's going to continue for years, I won't be able to work because I've got to be ready at the drop of a hat to go and collect our child. think about the options open to them and what that's really saying about that placement. If a child is out of school and a party is saying that they can't work, be aware of Section 19 of the Education Act. Each local authority shall make arrangements for suitable education at school or otherwise than at school for children of compulsory school age who, by reason of illness, exclusion, or otherwise may not for any period receive suitable education unless arrangements are made for them. So has your client spoken to the local authority about whether or not their Section 19 duties are triggered if the child isn't at school? Next slide. Other options to explore are is what's called the local offer. That's set out in Section 30 of the Children and Families Act for the legal team. For your client, it just means going online. Each local authority should have its own website containing what they say is their local offer in their area, and that can tell you what might be available in terms of services and provision. Does your client need to ask for a needs assessment? Are they in need of short breaks, care at home, aids, some financial help? It is worth seeing if that's going to be something that's viable if it's a very difficult situation for your client. Next slide. We're over now to Mike. So thanks for listening to me. I think we'll take some questions at the end.
Indeed. Thank you very much, Aimee. There should be a Q&A panel on your screen, so please do put your comments in there. Try not to put the questions in the chat box because we're unlikely to look at them, but we will try and have time for that. Also, for those of you who've been taking notes, that's very good for you. But the good news is that Aimee and I have done a set of materials to go along with this talk, and it's all going to come out on an email to you after this session. So moving on to my part of the afternoon, it's about an hour's talk condensed into 30 minutes. So I'm going to take a very quick canter through the principles and raise hopefully some issues that we've got towards the end. Standing outside the booth with a G&T. For those of you who might have worked it out, and thanks to Nick Allen KC for this, we're looking at comments from, I do apologise for missing the slide there, but it was His Honour Judge Booth in a case called L&L, who said that he was hoped that the term matrimonialisation was going to drop out of usage. In the back of Standish and Standish and the light of the Court of Appeal, no, it's very much front and centre with our cases at the moment. It's a fairly recent case. Some of you may have seen it. It was an appeal from Moore J, who dealt with it at first instance, a case called ARQ and YAQ, 2022 EWFC 128, for those of you who want to read it. Wife appealed and husband cross appealed. It came in front of King, Moylan and Phillips up in the Court of Appeal. And they really deal with the proper application of the sharing principles and the assets to which it applies. What makes an asset matrimonial and non-matrimonial, and how does a non-matrimonial asset become matrimonialized? So let's deal with the facts first. Husband was 71, very successful career in financial services. I think towards the end, he made something like 40 million in 3 years alone. He retired in 2007. He had 3 children from his first marriage. His divorce from his first wife, 2003. Wife, considerably younger. It's that old question, isn't it, from Mrs. Merton? So what did you see in millionaire Paul Daniels? Being somewhat cynical. 3 children for the first marriage, divorce from first husband, 2004. And she was Australian, rather like Mrs. George. And that is significant in this case. And we'll come to why in a minute. There was no prenup. They married in 2005, had 2 children, and there's a marriage of 15 years and 9 months. Total assets in the pot, 132 million. So very much a sharing case and not a needs case from the outset, you may think, but the issue of matrimonialisation was front and centre. Husband moved to Switzerland in 2003. in the year the relationship began, and wife and the children moved there in 2004. They looked to move to the UK from Switzerland. And most of you will know that there's a rather different taxation regime in this jurisdiction to that of Switzerland. And when you've got 130 odd million pounds, those issues can be very important indeed. So the parties came up with a cunning plan, or may I more appropriately suggest perhaps a cunning plan by one of their advisors. Looking at the assets, 180 million, 80 million, I apologize, of investments were transferred from husband's sole name to wife's sole name in 2017. A further 8.6 million in shares in a farming business were given to wife in 2017. This is a farm called Ardenside Angus. There were two farms with slightly different names, but these are the shares that were handed over to wife. And Jersey trustees were selected. There was a beauty parade of trustees in Jersey, probably not the most beautiful beauty parade in the world. And the party selected the trustees, but they didn't set up the trust. Why didn't they set up the trust? Well, the big advantage of this is that there's no inheritance tax if you're Australian. Wife was Australian, she was non-domiciled. So if the assets were transferred to her, healthy estate planning would mean that the assets could be passed down to the next generation free of inheritance tax. The reason why the Jersey Trust was not set up immediately was if it was set up immediately, then husband would not have alienated his interest in the assets that he transferred to wife. So whilst the trustees were selected, the trust was not actually set up. And so that was the cunning plan. And this is very much the smoke and mirrors that you often see when you have these cases. So this was an interesting setup. For those of you who like to read around the topic, you've heard of Richard and Judy's book club. Well, Mike and Amy's recommended reading for By the Pool this summer is, once you have finished reading your Financial Remedies Journal extract, is a book called Taxtopia. It's also on Spotify, and it is a very good audio book as well. And it's an accountant who used to work in the financial tax avoidance industry, deal with international clients, and he calls himself the rebel accountant. He's gone somewhat rogue and gives us an insight into how these schemes are set up. It's actually quite amusing to read. It's well written. It's lightweight in some respect, and also answers some questions that are on many of our minds. For instance, why do we have almost the greatest number of Starbucks per capita in this country compared to every other country? And the answer is the Irish Dutch sandwich, which he also explains on that. And the other interesting aspect for our fabulously wealthy clients is, why do so many of our European-based high net worth individuals have offshore yachts, whereas the Americans have relatively few? It's all in Taxtopia. And if you really want to put it in the Q&A, I can explain to you at the end of the afternoon. And for those of you who are of very high ultra net worth values, he also breaks down the tax benefits of having a yacht that you sail around Monaco, etc., etc. But down to more prosaic or less prosaic matters. Decision at first instance was that 112 million of the 132 was matrimonial. 80 million of the investment funds, as I said earlier, were transferred from husband's sole name to wife's in 2017, 80/60 in the farming business, and that's at a copy of the earlier slide. Wife was awarded 40% of the 112 million, 45, with husband receiving about 60%, 67 million. Overall division of wealth, 34% to wife and 87 to husband. I didn't mention it earlier, but wife brought some assets to the marriage, but nothing of significance in the context of the high net worth of this particular case. Wife appealed. to the Court of Appeal. She was represented by Richard Todd KC. And the arguments of appeal were this. What is the relevance of title? Because wife, of course, had that £80 million worth of portfolio in her sole name, as well as the shares in the farm. What weight should be given to the autonomy of the party to arrange their affairs, and the Madraka jurisdiction, or jurisprudence, I should say, was brought in on that. Does a transfer of title matrimonialize or dematrimonialize? And in relation to this, and I must admit, I tend to skip to the end of cases to work out actually what was the decision and what were the principles. This is a lengthy judgment. It's some 44 odd pages. The judgment starts at paragraph 108, to give you an idea of how long it is. Again, back on the reading list, it is actually quite interesting to read the arguments. And you've got Todd Casey arguing quite interesting points, dealing with why title is important in assets, and why that may actually make what is a matrimonial asset non-matrimonial, because the parties agreed during the marriage that assets would be held in this way. And an interesting thrust behind wife's case was, well, why, if she is married, should she be at a disadvantage compared to not being married? And there's aspects of discrimination being raised in those points. So moving on from those points, there's what weight to contributions and marital endeavour, and what were the critical factors within that, and do matrimonialised assets have to be divided equally? Because going back to first instance, although there was a finding that 112 odd million was matrimonialised, that wasn't necessarily divided 50-50. And that was very much the beef of wife's case. And the interesting argument put forward on behalf of wife was that, well, if these assets had been transferred to her, and husband could not reserve a benefit in these assets because of the inheritance tax points, and it would be an ineffective transfer if he did. Therefore, then they are no longer matrimonial assets that fall to be shared, but they all fall into wife's pot, and they do not fall to be shared. At first instance, and flirted with at the Court of Appeal, although not pursued, husband did try and raise the issue of mistake. Not practical mistake, because you might imagine he realised the mistake he made, having transferred so many assets into his wife's name, who then forgot to set up the trust in Jersey and said that they were all hers and not to be shared. But he did flirt with the issue of legal mistake, saying the whole transaction should be set aside. But that wasn't a point that was run in the Court of Appeal and was not determinative. So the whistle-stop tour of the various authorities by the Court of Appeal, and it's quite interesting for those who are interested in legal archaeology, going back to White and White. The concept of why sharing is important, and the non-discriminatory nature of it, and why changing title can be discriminatory, and actually the general irrelevance of title when it comes to looking at assets in the financial remedy context. The court looked at Miller, Charman, and Radmacher, and the point was Radmacher was interesting in that, well, if you can enter a nuptial agreement that deals with the distribution of your assets, well, why should there be any difference to putting weight on an agreements made between the parties in the context of marriage? And autonomy was very important in that regard. Dealing with the Radmacher point, the last point first, the Court of Appeal did point out that, of course, Radmacher and prenups are binding when someone enters an agreement with full legal advice, full disclosure, and importantly, in knowledge of the consequences of what they are doing. And pretty clearly, in this case, husband did not conceive the consequence of what he was doing. was of handing over £80 million to wife, who would separate not that long afterwards, and then say that none of it was to be given to him on divorce. So moving on. K&L was discussed in some depth, and it's a case that I have put a great stop by. It's where the Court of Appeal dealt with matrimonial, non-matrimonial property. You may recall it was a North London Jewish family who obtained special permission from the Court of Appeal because they discovered from their relatively modest living circumstances in North London, the wife was worth some 57 million pounds on divorce. And they wanted to be anonymized because they didn't want their children knowing that they were going to be fabulously wealthy growing up, which I think is a very admirable and laudable attribute and approach towards your children. Emphasis was put on heart. XW and XH looked to the link and very much emphasized the importance of the non-matrimonial source of the assets, which may diminish over time. I think you recall that the guidance in K&L, all the money was brought to the marriage by wife, who inherited shares from her father. And the conclusion of the Court of Appeal, and husband said, I'm a decent sort of a chap. I'll only have 40% of the matrimonial capital. The Court of Appeal said, I should Coco, your sharing starts at 0%, and it's going to be a needs-based case. And he had a needs-based award. And I walked away with round about 10% of the asset base, about 5 million, between 5 and 6 million, as I recall. And certainly not the 40% that he had contended for. So moving on, the key conclusions of our case in Standish are as follows. Weiss' approach, saying that title of assets was important, was contrary to White and could lead to unfair outcomes. And for those of us who deal with these cases day by day, not an entirely unsurprising suggestion in that regard. It would be discriminatory and entirely unfair to the court, would be returned to pre-White times, and it placed undue weight upon legal and beneficial title. And we know, dealing with our cases, that it's the matrimonial request that really is the important element when you're looking at what is divided. So the source of the asset is critical and not the title. The term separate property, which was a case advanced by wife, is entirely unhelpful in the context of the cases, so you are well advised to steer well clear of it. Radmacher could not be extended to matrimonial transactions, and the thought of having to rummage through the matrimonial attic and work out who said what to whom and what context assets were transferred from one party to another was wholly inappropriate, unhelpful, and was robustly rejected by the Court of Appeal. Moving on. The concept of matrimonialisation should continue to be applied, even for those who haven't put their teeth in properly this morning. And it would be wrong to state as the matter of principle, property which has a non-matrimonial source can never be subject to the sharing principle. We're coming back to the Mostyn-esque white leopard in that regard. But there may well be situations when, as referred to above, the fairness justifies this. The concept of matrimonialisation should be applied narrowly, and we bang on quite a lot in cases about matrimonialisation, and there does seem to be guidance in Standish that really it's a pretty narrow jurisdiction, no hard and fast line, and it's a general question of fairness in relation to it. There was a slight reformulation of K&L, so a case much beloved by myself has been slightly tinkered with. And really, these are the core principles, comrades, that we need to be thinking about when arguing these cases. A, the percentage of the party's assets, of an asset which were or might be said to compromise or reflect the product of non-matrimonial endeavour, is not sufficiently significant to justify an evidential investigation and or an equal division of wealth. So we're not interested in pettifogging in relation to this. It's got to be pretty clear and obvious what the element of non-matrimonial contribution is. So coming back to a phrase that I don't like, but 50-50 is the starting point. Technically, it's wrong, but practically makes a lot of sense. And maybe that's something that we need to bear in mind. Next, the extent to which and the manner in which non-matrimonial property has been mixed with matrimonial property means that, in fairness, it should be included within the sharing principle. Again, somewhat vague, but that is the guidance. And non-matrimonial property has been used in the purchase of a form of matrimonial home is an asset which typically stands in a category of its own. And we come back to paragraph 22, I think, of Lord Justice Nichols in Miller Macfarlane, which talks about the family home is usually treated as matrimonial property regardless of the source. But the Court of Appeal did affirm the jurisdiction of the cases, the jurisprudence, I should say, where the family home is not necessarily shared equally in relation to that. And there's a whole load of cases from a whole range of judges in the High Court level where they do conclude that the family home is not shared equally because of unmatched contribution from one party or the other. So source can still be relevant. So it's still an argument that we can deploy. But how were those principles applied to this case here? And it's here where perhaps we have some problems in the future. The argument that the 2017 assets, that's the 18 million of investment that was transferred to wife, or wife's separate property, was rejected. She was not the source of this wealth. And they did not agree with Moore J that this 80 million odd had become matrimonial property. And the reasoning that behind it was placing far too much weight on title. And that resulted in title becoming a determinative factor. So from that, if you place assets in your spouse's name, which were originally yours, for the purposes of tax efficiency or said inheritance tax efficiency, then that does not matrimonialize them in any way whatsoever. The more difficult point is in relation to the shares in relation to the farm. The farm was pre-owned prior to the marriage. Clearly it was husband's. The reason that the shares were transferred into wife's name was another cunning plan, namely that if wife had the shares, had a load of Class A shares, husband retained the voting shares, but she had the Class A shares, then the profits of the farm could be used to purchase her shares under Australian tax law, and there would be no income tax paid on the income from that rather large farm. The Court of Appeal accepted the finding of matrimonialisation, but if you read, that's paragraph 172. Though having said that, the Court of Appeal are very clear that there really wasn't much argument about the farm in this regard. And I think the real point we take away from this is if you don't argue a point in the Court of Appeal, they're not going to be very excited when it comes to conclusion. And if you read paragraph 170, they say, well, we haven't heard much argument. And on the basis of that, we don't have a reason to overturn the first instance decision that these were matrimonial assets. And in any event, it doesn't make much difference to our conclusion, because 20% was considered to be non-matrimonial and 80% was matrimonial. And so there was a division, a 40-60 division to account for those factors. But the strange result of all this is that the shares that were transferred to avoid inheritance tax were deemed to be non-matrimonial. But the shares that were transferred to avoid income tax were found to be matrimonial, which seems to me a very odd state of affairs. And I think really, if you look at it and we see how this develops in subsequent cases, I think you have to look behind paragraph 172 of the judgment. And the Court of Appeal isn't attempting to make a distinction between the two. That's simply not mentioned. And it seems to be one of the practical manifestations of the fact that the parties concentrated on the 80 million issue in relation to this case, and not the 6-7 million pound issue in relation to the shares. And again, at paragraph 178, you've got the quote there, and I'll skip over because I can see it is now 5-2. So the application of facts: wife had 25 million and husband 107 million, a very significant departure from equality, and a very good day in court for husband in that regard. So moving on, where does that take us to G&T? Now, G&T was a decision by Nicholas Cusworth in relation to this. And I'm going to skip over this slide because I've covered these points. A transfer of shares to a spouse for inheritance tax regime does not matrimonialize, largely a capital saving. And the transfer of shares on side did matrimonialize, but you need to look behind paragraph 172. So G&T, Nicholas Cusworth, KC, as he was then, Cusworth J, to the likes of you and I these days. This is a very, very good judgment if you are looking at trying to argue points of post-separation request in a business. Nick Cusworth goes through virtually all the authorities, analyzes them, and lays them out absolutely beautifully in what is a very erudite judgment indeed. And if you, in the materials pack, you've got a briefing note on this judgment that breaks it down. And it's a little bit old, from 2021, but it's virtually every case you'll ever need is set out and summarized in that judgment. And there was a focus on the equest being marital and premarital. And the helpful thing about G&T was there was some very good, helpful valuation evidence about husband. He contributed, I think it was some anyway, tens of millions to the value of the company post-separation. And we had robust valuation evidence of his business, which is so rare in these cases. And really, stepping back, Nicholas Cusworth took a view as to the valuation at separation, valuation at date of trial, looked and analysed how husband had reformulated the business, the investments. Some aspects had succeeded, some aspects had failed, but overall, great success, great additional wealth, and drew a line somewhere between the two arguments, concluding rightly, the point was you had to be fair about it. But in many of our cases, looking at sort of the lower value cases, shares are often shared between spouses in a company for tax efficiency reasons, for income tax efficiency reasons more than anything else, so that both parties at the bottom end of the scale can take advantage of their nil rate bands and the lower taxation rates in relation to those matters. If you look at a superficial interpretation of Standish, you say, well, guess what? When husband transferred shares in the farm to save on income tax, it matrimonialized. That's not what Standish says, in my view, at 172. It's the fact that the point simply wasn't argued on appeal. And the real takeaway is that if you transfer shares to a spouse for the purposes of tax efficiency, then you are not going to be matrimonializing that asset. I'm dealing at the lower end of the scale, on more run-of-the-mill cases. We deal with an awful lot of cases where the company is really a one-man, one-woman band, one-person band. Effectively, it's called a personal services company where someone was self-employed and they incorporate and they issue shares to improve the tax. Now, I've got a number of cases on the books where there's been some post-separation growth that's come in. Not the company's got massively bigger in any regard, but income has come in and it hasn't been spent. Understandably, the other side are going, I'm a 40% shareholder. I want my 40%. That is a matrimonial resource. It should be shared. The company hasn't grown in value, but the bank balance has increased. And it seems to me that looking at Standish, the points that giving a spouse shares to save tax doesn't matrimonialize the asset. Can't also matrimonialize your earning capacity and your income that you earn post-separation. So those are my takeaway points from Standish. That's the way that I think we should be looking at it. I think the matrimonialization of the farm is very much a red herring that just wasn't argued at appeal. And so the Court of Appeal were left with this is the only thing we can do. Now, that takes us neatly to 2 o'clock. It means that officially we have no times for questions, but I'm sure, Aimee, I'm okay to run over a bit longer if that's all right with you.
Yeah, absolutely. I can see that we've got 2 questions. So Antonia describes a situation where she has a client who has a child with what sounds like very profound additional needs, and there's a divorce. Client hasn't mentioned that her child has an education, health and care plan. She's only in receipt of carer's allowance and some benefits, and she's homeschooling. And Antonia is wondering if there's any practical or financial support and how she would go about requesting this. Certainly on these bare facts that I've been presented with, I consider it's very surprising that this child doesn't have an EHC plan. And your client's first port of call might be to contact the local authority, the education department of the authority, and ask for the child to be assessed. The threshold for assessment is very low. And if the local authority refuses an assessment, you actually have a choice of going to tribunal and the tribunal simply deciding whether there ought to be an assessment on the papers. So if it would be too much for your client to go through the whole tribunal process with an oral hearing, she could have it decided on the papers. There is an argument that you do not know that a child doesn't have special educational needs unless you assess them. Now, that's not the test, but the test isn't particularly high. And that could open up provision for the child. She may be entitled to provision at home. That is something that we call EOTAS, education otherwise than at school. Be careful though, EOTAS is not the same as electively home educating. EOTAS is where a child is unable to attend school, so effectively everything is put in the home, and that might be because of physical disabilities or mental disabilities. Of course, it's anyone's right, isn't it, to electively home educate. You do not have to send your child to school, but if your child has additional needs, EHCP, then to off-roll, you need permission. So it might be worth your client thinking about whether what she really wants is to electively home educate, or whether she wants some education to be put in place through the EOTAS package. She should probably also be in touch with Children's Services, have a look at the local offer, and see what entitlement she might have there. And then, of course, trying to take some advice to make sure that she is maximising all of the benefits that she's receiving. So first port of call, I think, is to contact the local authority. There's also a charity called IPSEA, IPSEA, that will help parents with the process. And I think that would probably be a good starting point for her. I've got another question about the time scale for a tribunal. I'm afraid in tribunal, we are in an even worse situation than in family. So there has been an absolutely huge increase in the number of people bringing applications to the tribunal post-COVID, because anecdotally people say that children having been educated from home has opened parents' eyes to perhaps previously undiagnosed issues. So we've got a massive uptake in tribunal. and sometimes it can take a year. So I've had cases in my diary, from January, February that are only going to take place later this year. Sometimes they will get through them quicker. Sometimes they will expedite them. But it can often be the only way that you will get provision in place, particularly if it is at a huge cost to a local authority, because they're going to be mindful of resources and budgets. I've been asked about permission consent in respect of EHC plans. I think that if you're in the voluntary disclosure stage, and these are both parents who would be entitled to see this EHC plan, then I don't think that you're in any difficulty. Certainly all the cases that I have done, both parents have been entitled to that information. It might be that one parent has taken a back seat. It might be that they've just let the other parent run with the tribunal process and they haven't involved themselves, but it doesn't mean that they are not entitled to that information, or that they're not entitled to come along to the annual review to discuss any changes. Obviously, you have to be mindful if there were any injunctions in place or something of that nature. I haven't had any difficulty, I'm trying to think off the top of my head, in putting EHC plans before the court. Of course, asked to be able to do that. I have found anecdotally that judges have been very open to having some independent evidence before them, particularly if there's a high level of acrimony and disagreement about what a child's needs may be, because here you're presenting to the court some independent evidence. The EHC plan will either have been approved by the local authority, it's their document, they're content to provide what's in it, or might have been approved after a tribunal has decided.
Right, Aimee, just on the disclosure point, and I don't think there's an answer to this, but one point I've come across is where you have someone over the age of 18 who has capacity, who's still subject to an EHCP, and is alienated from the other parent. So the other parent has been excluded from the EHCP because you've got an adult, they don't have parental responsibility, they can't share the information. You're now trying to go through the Children Act aspects and the financial remedy. One of the problems you have is that the child who has become alienated from the other parent is adamant that they do not want their medical issues disclosed to the other side. Now, I'm not sure there's a clear answer to what you do on that. Do you join the adult child to make their representations for privacy? Do you have the right to disclose the EHCP of other parties' information? Well, I don't think you do. Under MS in Sweden, this is very, very confidential information. But I mean, I suspect unless you've got an answer to this one, it seems to me that the issue is just very, very difficult and intractable. And the idea of joining a competent party who is neurodiverse to their parents' divorce is an horrific idea. But we haven't yet worked out a solution to this one.
Yeah, that is a much more difficult scenario, isn't it?
Yeah.
I think you're absolutely right. And that's, I think, navigating that on a case by case basis, I can completely see how that issue can arise. Fortunately, it's not one I think that I've had to encounter just yet. The judges have been open to having some sort of independent evidence. I haven't had any difficulties with local authorities, because of course the local authority will have been a party to proceedings if there's been a tribunal. So you might want to check with the local authority, are they content? And there's no objection to use of the document. If you're not able to use the EHCP itself, I don't see why you can't ask the court's permission in the right circumstances to use the reports, because you'll have reports there that contain an awful lot of information, and they can be really helpful. I've probably focused on where you're trying to demonstrate that the child has got a high level of need, But likewise, you might be in a situation where your client is saying, I don't believe that the needs are at that level. I think they've been exaggerated, in which case your evidence might help the court just put it into context. Who is right? Does the child have a high level of need or not? So certainly I think it's worth making your applications to have those documents in front of the court to clear up any factual disputes.
Right. Well, there we go. So questions for Aimee, 4 questions for me, nil. But there we go. Clearly, Aimee's topics are much hotter than mine. Anyway, thank you very much indeed for attending. Thank you very much for your time. We've run over very slightly. As I said, the materials are coming out, and you know where to find Aimee and myself if there are any run-off points from this. Thank you very much for your time, and good afternoon.